Hi everyone, welcome to today's webinar. My name is Rick Bridges and I'll be the moderator for today's event, which is Shipper Contracts and Master Service Agreements, the Devil's in the Details, less commonly considered issues in shipper contracts. Today's presentation is scheduled to run for 50 minutes with an additional 10 minutes for questions and answers. Please note that all attendees will receive a link to a recording of this webinar and the accompanying slides in an email within the next few days. Once the webinar is finished, a brief survey will launch and we ask that you please complete it. We want to know what other topics we can address for you in the future, so please take a minute and let us know what you want to cover. Remember that the certified export specialists and certified customs specialists are eligible for one CES or CCS credit for attending today's webinar, and if you haven't logged in your NEI CCS or CES ID number upon registration, just email it to infospot@roanoakgroup.com. Again, that's infospot@roanoakgroup.com. As far as some housekeeping before we get started, just as far as the interaction today, throughout the webinar, we encourage you to type your questions into the question box in the control panel, and what we're going to try to do is answer the questions along the way today. If we have time to do so, we're going to try and hit as many as we can, but if we can't get to all of them, we'll try and circle back and hit as many at the Q&A at the end of the presentation. And certainly if you have any very detailed questions, feel free to just email us and we can hopefully answer those in a detailed fashion on a later time. So it's now my pleasure to introduce today's presenters, Jake Fisher and Nathaniel Saylor, both partners of the law firm Scopelitis, Garvin, Light, Hansen, and Fury. The three of us actually have the privilege of sitting together on the Regulatory Affairs Committee of the Air Forwarders Association. And I think today's topic is one that's very near and dear to us. So hopefully you'll find that our perspectives are useful in your own dealings with shipper contracts. So I guess just to start, you know, contract negotiation, it's really a meeting of the minds, and one where counsel plus risk management and the client really needs to come together and discuss it and make sure that all aspects are really taken into account before agreeing to the contract. From an insurance standpoint, it's really important to remember that most insurance policies exclude contractual liability in the context of a master service agreement. So it's really important to make sure that things like E&O, general liability, cargo liability policies will respond. And, you know, to that point, a question that often comes up is, you know, why can't I get blanket contractual liability coverage? Or why can't my contracts be automatically covered? And really the short answer is cost. You know, because master service agreements vary so much, there's really no way to create a catch-all type of coverage without that insurance becoming unaffordable and unrealistic. Now, there's some policies kind of designed for very large companies that have broader allowances for contracts, but the flip side is those policies are typically loss rated, and you know, if paid claims hit a certain threshold, those premiums are going to ratchet up quite a bit. So at the end of the day, the insurance company has to be protected in a way so that it's not going to significantly hurt them in the end. So really it's a balance. It's going to be a balance of the coverage versus the premium. And for the most part, most shipper contracts are looked at on a case-by-case basis, and that's really the best way to do it. So I'm going to hand off the discussion now to Jake, and why don't you take it from here?
Sure. Thanks, Rick. We can stay on this slide. Before we get going here, let me add my thanks on behalf of the Scopolitas firm to all those attending today and to Rona for hosting. We appreciate it. I'm Jake Fisher in the firm's Philadelphia office. I'm joined by my partner, Nathaniel Saylor, who's in our Salt Lake City area office. And without further ado, one of the things we wanted to jump into before looking at some specific issues that maybe don't get as much press, for lack of a better term, is to talk about this RFQ process and kind of how things work. I had to, prior to coming to work at the firm, when I was in-house with a logistics company, I had the chance to be involved a lot of times with this process, and seeing it also with respect to my work with firm clients, is that it often seems to be backwards with respect to the process from the forwarder's perspective. And think about this in terms of the pricing submission. This RFQ or RFP comes out. The shipper is detailing their lane segments and delivery requirements, et cetera, and your company submits its best pricing to get into that process, and if you're lucky, you get a finalist status or something along those lines. And it's usually at that point that the contract comes at you, usually with the expectation that you're going to sign it quickly, and usually the not so subtle pressure that you're going to, that the shipper is not going to be really receptive to a lot of redlining or a lot of pushback on the contract provisions. So in addition to that, you're going to see, obviously, there's organizational pressure. Your sales folks and marketing folks have worked very diligently to get these rates together and get the business. So there's a lot of pressure coming from both sides. And oftentimes, the contract will talk about issues that affect the pricing of your services. So, for example, you might see the expectation in the contract that you'll take on full value liability, or some species of that, or some other aspects of the contract that now that you have your pricing in, you're already stuck because your pricing that you submitted is perhaps based on your standard terms and conditions and the limitations of liability that you enjoy in there. So right off the bat, you have a mismatch in terms of what we attorneys call the meeting of the minds, and keeping in mind that a contract is really just the written expression of the agreement of the parties. So this process seems to be sort of backwards in creating a relationship that's off to us on a bad footing from the very beginning, because there's a misunderstanding as to how the parties are going to see the relationship. The takeaway, I think, on that is as Rick was alluding to, is to attempt to try to discuss as much upfront with the shipper as to your understanding of how your rates are structured, how your business operates, your understanding of the key areas of not only cargo damage and loss liability, but other issues that come up in the contract. Okay.
Yeah, good points, Jake. And I would say, just one experience that I've had is oftentimes you have the traffic manager that you might be working with unaware of the real details of the contract. It might sound odd, but in some cases it's really two different silos. Traffic manager is trying to put together the relationship, and then you might have risk management or the shipper's counsel trying to negotiate the details of the contract. So if that's the case, I would say if you kind of feel that's the way it's working, try to bring that point of contact that you have, traffic management or whomever, into the negotiation and the conversation. Example I have, it could be that the traffic manager is reaching out to you, knowing that you're a property broker or a forwarder, yet management is trying to get you to sign a carrier contract, clearly not really designed for what you're going to be doing. So I think traffic manager knows that you're probably going to provide solutions where trade lanes are going to be fulfilled by you, where a carrier might not be able to help out. So clearly there's a desire, but the contract itself might be getting in the way. And I've really seen a lot of contracts kind of get in that way of the shipper aligning themselves with a logistics provider that's kind of the perfect fit for that solution. So know that you might need to kind of be creative in bringing other people to the table.
Absolutely. Thanks, Rick.
You're welcome.
We can move on to the next slide.
Sure.
Okay. Yeah, thanks, guys. This is Nathaniel Saylor, and to echo Jake, I want to thank Roanoke and all the attendees today for tuning in. As you've kind of heard, this is a wide-ranging webinar, so we're going to start getting now, I think, into some very specific contract issues that come up. And you know, the issues that we're going to be talking about might be relevant to you, in some instances might not. So as an example, if you're purely a property broker, you know, you might not be as concerned about some of the things we're going to be talking about with respect to international bills of lading or airway bills or ocean services. But on the flip side, if you are an international forwarder, you might be less concerned about some of the you know, aspects having to do with signing motor carrier contracts, which is an issue that our broker clients typically run into. So, you know, we're trying to cover a wide range of potential issues for logistics companies here, and the first one that we're really going to get into specifically here, I'll touch on very briefly, and that has to do with how do you address ocean services in a contract, because a lot of times what we see is you know, you're going through the RFP process, or you know, you're presented with a business opportunity from a customer that maybe doesn't understand some of the limitations that apply to arranging international ocean transportation. And what those limitations are, in particular, are that the Federal Maritime Commission, which licenses ocean transportation intermediaries, including NVOCCs, takes a very strict view on what you can and cannot do if you are not a licensed NVOCC. And essentially what they're going to say is you cannot arrange ocean transportation in your name and bill for it in your name if you do not have an OTI license as either an NVOCC or an ocean freight forwarder, or if you're a foreign entity, then maybe as a registered OTI. So in other words, you essentially, the first stopping point is, do I have the license to do the services that I'm being requested to perform under this contract? If you do, the next issue is this. The FMC has some very strict rules about how an NVOCC, as an example, can arrange for transportation. So as an example, and I'm sorry, I'm getting some feedback in the line. I don't know if there's somebody that can mute their line. I don't, maybe that's just me. But as an example, with respect to a contract that covers ocean services, under FMC regulations, an NVOCC is required to contract for business in a very specific number of ways. One, you can provide service pursuant to your published tariff, which would be pursuant to your bill of lading. In other words, that is just rack rate service. It's the same rules that apply to everybody. It's governed by your bills of lading and your published tariff. That type of process doesn't account for a signed customer contract where you've got different terms of service other than your bill of lading or tariff. If you're providing service pursuant to your bill of lading and your tariff, then those are the rules that govern that transportation, and you're not allowed to give somebody a better deal. The same way with an NRA, or a negotiated rate arrangement. An NRA assumes that your bill of lading applies. So if you want the freedom to freely contract with your customer for international ocean transportation, the trick there is you have to enter into what's called an NVOCC service agreement, or an NSA. The problem with an NSA is it's still pretty limited. It's not just freely contracting for service. You have to file your NSA with the FMC. It has to include minimum quantity commitments from the shipper, where your customer is agreeing to provide you a minimum quantity of cargo. And if you jump through those and some other hoops, then you're allowed to essentially freely contract for the service. But if you're just signing a contract that covers ocean service and you're not treating it as an NSA, you're technically providing service pursuant to your tariffs and bills of lading, and I'll almost guarantee that your contract is going to conflict with your tariffs and bills of lading. You're probably going to have different, even if you don't have different rates, you're going to have different terms of service. And that really limits what you can do with those contracts. So again, it's important to inform your customer up front what rules apply when you're arranging that international ocean transportation and what limitations apply to the contracting. So that's all I had on that slide.
Okay, thanks, Nathaniel. Just a reminder for everyone to type in their questions in the question box on the GoToMeeting space down below, and we'll try to read those as they come up.
Okay. There we go. Okay, this is Jake again. We often hear and get a lot of questions about liens, and this is probably a subject that could be a 2 or 3 hour webinar in and of itself. But we wanted to touch on it because it's one of the things that you'll see in contract negotiations that shippers will try to gut out of an agreement or cut it, or in their agreements add in that an affirmative obligation that your company is going to waive its lien and possibly make an affirmative representation that it's going to ensure that any and all subcontractors that are used are going to have their lien rights waived as well, which obviously has a lot of difficulty for multimodal logistics companies that are engaging a lot of different contractors and carriers to perform services. So just at a high level, we want to get you an awareness of kind of how these things work and what you're waiving. And really the issue here is first off that carriers themselves of all types will have a lien right, that arises basically a common law. And this is something that goes back to ancient times in maritime law, that a carrier has an absolute right to withhold delivery of cargo against payment for the services for that particular piece of cargo that's in their possession. And that's thus the name, a possessory lien. The possessory lien has been expanded on by statute, both at the state and to some degree at the federal level, under the Uniform Commercial Code, which has been adopted in all states. And also there's references in, like I said, federal law as well. And oftentimes under UCC, the simple right to withhold payment on cargo, or rather withhold delivery of cargo as against payment, is extended to allow for an entity to act on its lien and actually sell the cargo. So then sort of the next level, if you want to think about this, is the contractual general lien. And this lien is really a creature of contract. So when you're giving up and waiving liens, you're really waiving two different types of liens, assuming that the contractual lien is actually in your standard terms and conditions, which oftentimes it is, or your airway bill terms or other things. Usually in there, there's a provision that allows you to assert a general lien. And this is far better protection for your company because it allows you to withhold delivery of a shipment pending payment. And also in the fact if you haven't been paid for other shipments previously delivered already, that you're not going to get yourself in trouble with asserting the contractual lien. Now, obviously, with respect to actually doing this, we would recommend that you contact your attorney before you try to do so, because the enforcing a lien, whether possessory or under contract, can lead to a pretty nasty thicket if not done properly, and it can expose your company to counterclaims for tort liability, in the fancy word which is called conversion, which is essentially the civil analog to theft, that the owner of the cargo would say that you're unlawfully retaining their cargo. So there's a number of different sort of levels to this analysis, but for the purposes of today, We wanted just to have you understand the difference between a possessory and a statutory lien, as well as the one that's in your contracts, and the fact that you're likely going to see a shipper try to get a blanket waiver of all lien rights with respect to your business with them. Obviously, the main question and takeaway that brings up is really the need to have a discussion with the shipper as to whether that language in there is absolute, and if so, really to have a discussion with the shipper, because this is really your only primary and most powerful weapon to ensure your security in getting paid. So it's an issue that you should not take lightly. It's obviously going to be a difficult discussion to bring up in a negotiation with a shipper that you feel that perhaps they're not going to be able to pay your bills, so you want to retain your lien. But perhaps it gets at least the issue on the table so you can discuss whether there's different ways to accomplish the shipper's goal in having whatever need that they have for you to try to waive a lien or have subcontractors waive liens. But we can at least get it on the table as discussing the financial aspects and what other, if your company's going to waive its lien, what other types of security can it have in place to ensure that it gets paid on shipments that it's already delivered, or goods in its possession, and what rights it would have in the event that there was some sort of dispute over payment.
Great, thanks, Jake. We do have a couple questions here, just if we can go back real quick. The acronyms NSA and NSC, what do those stand for?
Yeah, the NSA, again, sorry about that, that's an NVOCC service arrangement. That is a creature of federal regulation pursuant to the Federal Maritime Commission regulations. The other question, I think, was on the NRA, or that is a negotiated rate arrangement. And again, that's an ability or a flexibility that was built into the regulations a few years ago. It would allow an NVOCC to avoid having to file tariff rates, but still have to rely on its tariff terms and conditions of service when providing service. So it's a bit of a hybrid where it's not as it's not a full-on service contract where you can just freely negotiate terms, but you can freely negotiate rates if you jump through some hoops that are applicable to NRAs or negotiated rate arrangements.
Thanks, Nathaniel. And Jake, one question here on liens. How does an NVOCC protect themselves from when the containers are abandoned by the consignee?
Well, that's going to be I'm going to punt on that one, because I think we could probably have an all-day discussion on that. But it's certainly something that we see, and Nathaniel works on this as well. We see this in reviewing and drafting NVOCC bill of lading terms, that the lien language is typically in there. I'm going to have to punt to say this is kind of on a fact-intensive analysis of what can be done in the event of a container being abandoned. Obviously, the bigger issue sometimes is if you're an NVO, your interplay with the carrier and what you're going to be responsible to the carrier with regards to that container.
Okay. An insurance solution, Roanoke's created what we call abandoned freight or demurrage coverage, and it seeks to provide some level of coverage for that exposure. So that's something that you could certainly talk to your Roanoke trade representative about. Okay.
All right. So I think it's back to me for a quick discussion on governing law and venue. I did want to mention a couple of specific points that Jake hit on, but really flesh them out or bring them to the forefront of the discussion on the lien issue just very briefly. And that is, as Jake mentioned, one of the issues you're concerned about when you're negotiating a contract is the shipper is going to say, I don't want anybody to have any lien on my freight. And, Jake mentioned subcontractors, and what he's getting at there is if you're an NVO, as an example, you're likely not getting the steamship line to waive its lien. So not only when you agree in a contract to waive any and all liens and make sure there's no liens on the product, a lot of times in your customer contract, it'll actually require you to go in and remedy the situation if there is a lien. So as an example, if the steamship line were to seek a lien on cargo because maybe you haven't paid, well, now all of a sudden you've got an issue with your customer on the one end and then the steamship line on the other. So you can really kind of buy yourself a nasty liability with that clause. And the other is, again, just to bear in mind, whether or not you actually have that common law lien will depend in part on your role. If you're purely, as an example, a property broker, the law doesn't give you a lien because you're not a carrier and you typically wouldn't have possession of the cargo. So that contractual lien that Jake mentioned takes on some added importance. So again, some points there I just wanted to make sure they got kind of brought out, as we're obviously trying to cover a lot here in a short amount of time. Speaking of short amount of time, I'll hit this governing law and venue slide and I'll hit it pretty quickly. In just about every customer contract, they're going to set venue in their backyard. And they're probably also going to set governing law in their backyard. So in other words, the state where they are primarily headquartered. So Rick, if you could go ahead and advance the slide, please. The in that, and so we always get the question, oh, well, is this state law okay? And there's really not a good answer to that question prospectively, right? Because it really depends on any number of issues that might come up under the contract. Some issues might favor you in a particular state, some might not. And so we don't usually get too hung up on governing law, what state's law is going to govern the interpretation of the contract between the parties. But what can get ugly is the venue provision, especially in your customer contract, because that's going to require you typically to go and fight claims, again, in their backyard. So you're going to have travel expenses. You're going to have to get local counsel in that jurisdiction. You're going to have to jump through a lot of hoops to, go and effectively litigate that dispute. And another issue that can arise, and it's mentioned here, is kind of the two-front war, if you will. And that's it's a nasty issue, and unfortunately there's not a very good solution to it. And what we mean by the two-front war is you've agreed to a venue clause in your customer contract, but then, on the back end, if it's a claim that involves the carrier, you might have an agreement in place with the carrier, and maybe they've agreed to your venue provision, especially if you're a broker and they're a motor carrier, you can usually get that through. But even then, that probably set venue in your backyard. So now if you want to go after the carrier, technically your own contract with them says you've got to fight them in your backyard, but you're fighting with your customer somewhere else. It's really compounded when you're talking about maybe a steamship line or a rail carrier or an air carrier, where you're probably not going to get venue set in your own backyard with those providers. So now you're going to have to travel to fight, on both fronts. And again, there's really not a clean way to address that issue. What you could try to do is, if you have the pull to get with your providers a venue clause, you could try to get one that either sets it in your backyard, or if there's a dispute involving a third party that, for instance, an indemnity claim might be covered under your supplier contract, to have your supplier agree that they're going to fight that, in the same court, in the same proceeding, wherever it may be. But that's not a typical clause that I see. And it's so again, that you kind of end up in never land in some instances, and it might be that you can negotiate with everybody and get everybody to kind of submit to just wrapping everything up in one proceeding. But it's a thorny little issue, and one that our clients typically just kind of give away. And I get it, it's always tough to get a favorable contract and you have limited negotiating capital. And frankly, this is one where our clients, and I don't fault them a bit for this, frankly give on the venue and jurisdiction clause pretty readily.
Thanks, Nathaniel. I would add, that when it comes to venue, just make sure that you familiarize yourself with the policy territory. Some insurance policies, may have a worldwide claims coverage basis, but the claims venue may be limited, and typically for a good reason, because there's some countries that really kind of favor the home team, and unfairly as it might be, aren't very open to providing a true fairness doctrine within their legal system. So those venues, there may be negotiation, so you might be able to expand the coverage policy territory as well, and that's typically seen with, say, an E&O policy, where if you're providing predominantly domestic services or dealing with U.S. companies, you might be able to save some money just having your coverage limited to suits brought within the U.S., but you can broaden that out to cover additional countries as well. And I would suggest looking at that on general liability as well, because certainly the shipper contract is going to address potentially third-party liability issues as well.
All right. I'll just add, Rick, before you move the slide forward, I'll just add, just by way of a war story there, right on point with what Nathaniel was talking about. A number of years ago, I was in negotiating a contract like this, and believe it or not, we really did come to a bit of blows over where the venue was going to be, not so much the law, but the venue. And one of the things that broke the impasse was actually selecting a venue that was neutral, and quite frankly, I think would have been equally painful for both parties to attend court and to hire counsel in that venue. So by doing that, selecting that sort of third option helped to break the impasse. So you never know. Sometimes it just takes a little creativity to get to the goalpost. Okay, so we can move on to indemnification. So at the risk of everybody glazing over, we'll try to keep the comments on this pretty sharp. Indemnification clauses are always something that comes up in contracts, and nobody ever likes to really talk about them. Oftentimes, they'll come in two kind of formats. The first being one that is blatantly written in favor of the shipper and puts all kinds of onerous responsibilities on the forwarder or the logistics company. The second type, which sometimes are even actually harder to negotiate with, are the ones that are what we would call like a mirror image, where there seem to be equally onerous and broad indemnity obligations on both parties. And usually the response on that second type, when you try to negotiate anything, is, well, we made it equal on both parties, so what is your issue with this? And that's a tough thing, first of all, to deal with. But it's important to look at this. And the particular issue that we wanted to focus on today, which is a checklist item for us all the time when we're looking at these contracts, is making sure that there's an exception in a broad indemnification clause for anything related to claims on cargo loss and damage. It seems pretty basic, but as you all well know, any standard issue logistics contract is going to have a separate provision that provides a discussion on the liability of the forwarder or logistics company. It's going to describe, hopefully, reasonable claim procedures if those are applicable to the business that's being done. But the point is that there's a whole section dealing with those obligations. So there shouldn't be a backdoor for a shipper to claim liability for cargo loss and damage under an indemnification provision. So it can be as simple as simply just a parenthetical that's put in there, excerpting claims for cargo loss and damage as handled in section whatever. And we recommend that would be a basic thing to look at first when you're reviewing these contracts, to make sure that exception is in there. Again, you don't want to create a separate avenue potentially for liability. and where that liability on an indemnification basis might be not constrained by the other provisions in the contract that hopefully provide some measure of relief, or at least a defined idea of what your company's liability is going to be in the event of loss or damage claims. And Rick, I don't know if you have any comments on that with respect to insurance.
Well, I guess one of the common questions that we get is, oftentimes we'll see these contracts and they're kind of ill-worded to fit logistics in the first place. They might be a very general service contract agreement. They don't have any kind of cargo or loss limitations of liability, yet they have insurance limitations of liability. And could you speak maybe to the absence of the limitations of liability, or even addressing any cargo loss, and how those insurance limits might work?
Certainly. I think I'm sure Nathaniel would want to jump in on this one first, but or rather after. My observation here would be just to have a lot of, if you see a contract like this, don't make the assumption that merely the fact that there's insurance provisions in there, that those are going to be interpreted by a court ultimately as being equal to a limit of liability. It's important that both of these aspects be set out separately, and you not make the assumption that simply because your insurance obligation is X, that's going to be the maximum liability for cargo loss and damage under the contract.
Thank you. This is Nathaniel. I completely agree with that assessment. I mean, in other words, liability is one thing, insurance is another, and you can bet that your customer is not going to give you a free pass if you haven't capped your liability based on the fact that there was an insurance limit in the contract.
Okay. Another thing that we see quite a bit is maybe it's due to the shipper's overzealous counsel trying to do the best for the shipper, in asking for very high limits of liability and high limits of insurance. When we talk about the contract and the commodity that might be being hauled, and values and things like that, there's a big difference between the actual dollar amount that might be moving in that supply chain and the limits that are being requested. What kind of advice can you give to try and bring those limits back to something that are a little bit more rational?
Yeah, this is Nathaniel. I'd take a pass at that one maybe. I think I've got some clients that I think do a really nice job of framing that discussion on the cargo side in terms of rate. In other words, look, customer, and it's probably easier to speak in terms of a property broker as an example, because a lot of times what you'll see is maybe a customer saying, oh, you've got to have $250,000 of insurance. You've got to have carriers that have $250,000 of insurance for every trailer that's hauling my stuff. And and so then you start to press them on that. Now, oh, well, the vast majority of our stuff's 100,000 or less, but every once in a while we have a one-off load. And so then the discussion becomes, well, you're really requiring us to use a more expensive carrier pool. And so that's something that we can do for you, but really, it sounds like what you need on, maybe it's an 80-20 rule. Maybe on 80% of your moves, you really only need 100,000, and we could probably do better on the rate if that's the case. Now, so I think that's a good discussion on the business side as far as, kind of the, it shouldn't. Sometimes I feel like the industry as a whole doesn't do a great job of kind of tying liability and exposure to rate. But I think the customers or the clients that are pretty successful in those discussions, that's how they try to frame it is, hey, increased exposure, that's fine. It means increased rates. And do you really want to up your cost on every move when you really only need it on 20% of your moves, and then build in a mechanism to declare those higher value shipments. So I think that's on the cargo side. On the the true liability side, that kind of depends on what context we're in. But again, if it's a requirement from the customer that you use maybe a motor carrier that has 5 million or 10 million of insurance, the discussion there is very perfunctory, and that is, look, the pool of carriers starts to shrink very quickly, when we start talking about those higher insurance limits. Now, that is you need to be careful in that discussion, because if you have assumed, which, back on the, more so on the indemnity slide here, one of the things in that agreement, you want to be very careful that you haven't assumed a duty to indemnify against the acts and omissions of the motor carrier. And as long as you haven't, then, really what you want to do is try to, again, frame that discussion of, look, if you're going to essentially gut the pool of carriers that's available for me to tender your freight to, if you have these high auto liability limit requirements. But short of that, if it's in there, if it's in your contract and it says 5 million, and you put a carrier on it that had $1 million or $750,000, you just bought yourself that liability, the difference between those two numbers. So that's a real important one. If you're going to agree to it, you need to abide by it, because otherwise you can essentially buy yourself the difference in a breach of contract claim.
Good points, Nathaniel. And I think a lot of this, it goes back to my point of bringing everybody to the table and making sure that the kind of the silos are torn down, so you can really have a candid conversation as to finding a true logistics solution, not just kind of dealing with the contract parameters in a little bit of a vacuum.
That's right.
Okay.
Agreed. Okay, I'll take this one, and we'll talk a little bit about a bit of a different issue. And this is one that we've seen come up more and more, particularly in the last few years, as there's been more and more attention on anti-bribery, anti-corruption laws, and the proliferation of those around the world, as well as Uncle Sam's proclivity to make a lot of money off of Foreign Corrupt Practices Act prosecutions, and also hacking and disaster recovery issues related to data breach and things like that. So one of the things to really look out for, and what we've seen in these shipper contracts, is you'll have your standard representations and warranties, but sometimes they'll slip in things that are related to these to compliance with these particular policies. And we've seen them where they'll refer to a policy and representation and warranty in the body of the contract, and then refer to Exhibit X or Appendix E or whatever. And you go to that one, and you'll see either perhaps an embedded document, maybe the hyperlink that's reaching out to a website where this code of conduct or whatever policy is on there. And you're warranting that your company is going to be in compliance with these various things, and they can be extremely onerous. And it's important, I mean, obviously critical. You hear it from us lawyers all the time. You got to read this stuff, particularly for even small to mid-sized companies, because these requirements a lot of times can be extremely burdensome. In the case of two different aspects I'll talk about here that I recently had experience with was one with disaster recovery. The policy and the requirements of the shipper's policy were far-reaching in terms of a comprehensive written disaster recovery policy that demonstrated industry best practices. And a lot of those types of representations in terms of best practices, well, we're a freight forwarder, we're a property broker, we're a logistics company, we're not an IT company. So they had it was very difficult to even get the client's arms around what they were going to have to warrant their compliance with. And the same on the other side of things, supplier codes of conduct will often dovetail with anti-bribery, anti-corruption. Companies are getting more and more cognizant of the potential for liability that they can incur by virtue of the acts of their intermediaries, i.e. your company and downstream the companies that you're working with. So for international forwarders that are working through agents around the world, you have to think about if you're warranting your compliance with certain anti-corruption laws or a supplier code of conduct that is obligating compliance with law, you have to think about this and think about your relationship with those overseas agents. How long have you known them? How well do you know them? Do you have a contract in place that has meaningful provisions requiring them in turn to comply with the laws of not only the U.S. but in their own jurisdiction or any other laws that might affect or have jurisdiction over their actions? And as I alluded to earlier, around the world there's a proliferation of countries that are either more aggressively enforcing their anti-corruption, anti-bribery laws or drafting their own new ones. So you have this sort of ever-growing thicket and nexus of different types of laws. It gets very, very technical, and you have to really consider what your exposure is going to be under those provisions. You can move to the next slide.
Sure. Just real quick, Jake, oftentimes we see this, and it's not just the employee that's pulled into it as far as codes of conduct, but it could extend out to the vendors. So I guess my question is, what kind of chance does a contract like that have as far as being able to push down liability onto the vendor or onto the agent? And I guess the second part is, in the absence of a contract, say with a carrier, does like a MOU, memorandum of understanding, help, or is that really just lip service and it's not something that can be worked on downstream but has to be effectively changed in the contract with the shipper?
Yeah, so as to the first question, I mean, again, what we're going to get back to is that a prosecution is going to be based on an agency theory. So if you're an international forwarder and you're engaging in conduct through your own agents, I mean, that the liability for actions that you're taking on behalf of your shipper client can flow right back to them, and that's the genesis of some of these policies that the shippers are aware that their intermediaries, whether that's their transportation company, whether that's their whatever company or vendor that they're using, can expose them to liability by virtue of its actions out in the field and the actions of its, in turn, its subcontractors. So I think on your second question, I think if I understood this was in terms of, all right, if you have signed a contract like this warranting compliance, what do you do with respect to your vendors? What we've seen is that you do have to have a discussion. It's obviously a more difficult discussion to have with overseas parties, but it's becoming more well known that these sort of requirements of having express provisions in mutual agency agreements with regard to compliance with law, they're becoming a little bit more accepted. I think you can have a little bit more of an open and honest discussion about what's going on and how they're doing business, but it's still a difficult discussion to have because people don't like to be, and particularly if your company as a logistics provider has been using a company overseas in a particular location for a number of years, it's basically a relationship built on a handshake and emails. They may not be very happy about all of a sudden having a discussion about that centers on the possibility of them paying bribes to customs or other government officials, and you're concerned that they might be doing so. So it's a delicate thing that you have to handle, but it's absolutely important. Does that get at your question, Rick?
Yes. Thank you.
Okay. Right. So just real quick, the next slide is just again, what this creates is if if you sign off on a contract like this, what you're doing is you're exposing yourself not only to potential breach with respect to the underlying laws or regulations, but also to just breach of contract. And in the recent contract that I looked at, in the actual appendix of the policy, it was allowing the shipper termination rights and also the ability not to pay any invoices merely upon the suspicion that something not good had happened. So kind of a guilty until proven innocent mindset with respect to the policy compliance. Not good to be holding the bag if you're the forwarder or the logistics company, and all of a sudden they just send a notice saying, we think something happened, so we're going to stop payment on all invoices, and having no implications for their conduct in doing so within the contract. So obviously something there that we push back on quite a bit. So really important to not pass over those documents or the hyperlinks and take the time to go in there and fully understand. And again, to what you said earlier, Rick, it really loops back to educating yourself on the customer's expectations and having a clear-eyed discussion about what they need and what actually has to be in this contract.
Good point.
All right, I think we're back to me, and the next couple of slides, this is kind of a broad discussion on mischaracterization by your customer of your role in the transaction. And this can come up in a million different ways. I mean, as Rick said, sometimes what we just see is it's just a general service contract that your customer might use for a janitor supply company or for logistics, and it's just kind of any services under this contract. I think more specifically to this discussion, what we're concerned about is being miscast, if you will, as the carrier. And there are a couple of kind of big ticket concerns with that. One is cargo liability. In other words, if you're trying to take the position that I'm hands-off, I'm a logistics provider, and I'm not liable for cargo loss and damage, then it is very important to clarify that in the contract. But frankly, a lot of the times what we see is our logistics clients are essentially assuming that liability on the theory that they're going to go back and subrogate it. And so what the other kind of big bucket that they're concerned about as far as having their role miscast is essentially being liable for the acts and omissions of the carrier. In other words, whether that is simply, saying I am the carrier under this contract. If you're a property broker and you're presented with a motor carrier contract, which happens more often than I would care to admit, that contract, is going to say things like you're providing the drivers, you're providing the equipment, you're ensuring the drivers are qualified, you're going to comply with all applicable federal motor carrier safety regulations. So you're essentially giving, you're warranting, if you will, the conduct of the underlying carrier by saying that you're going to make sure those things happen. And what that does is open you up to, highway accident or personal injury type exposures. So, that's one where you really want to be careful about what the contract says, because, having that motor carrier contract and just adding a line that says, well, hey, I'm a property broker, not a carrier, well, that's fine. But if you leave in all of the other stuff about how, as the, quote, carrier, you are responsible for the drivers and the equipment and, the highway accident liabilities and the indemnity clause, then you really haven't protected yourself. Now, if you're operating in the international space, you might be saying, well, heck, my bills of lading or my airway bills, they refer to me as the carrier, and that's how everybody does business. And I would say that's by and large, that's correct. Where the issue comes in is, again, what's typically in the customer contract, because it's all those requirements in the customer contract that make that being referred to as the carrier or having carrier type responsibilities much more toxic to you. Because when you think about a bill of lading or an airway bill, it's not talking about indemnities that you owe to the customer. It's not talking about the drivers and their compliance with the law. It's talking about things like the cargo and cargo liability. And so again, if you're willing to accept the cargo liability, being referred to as the carrier maybe in the airway bill or the bill of lading isn't as big of a deal. But when you think about all the things that are going to be in an onerous and unfavorable customer contract, that's where really that term becomes problematic. So you go ahead and advance the slide there, Rick. We've got one more slide on this. And here, all right, so now what can we do to help kind of make sure that my role is properly defined? And there's a few things. I mean, in a lot of logistics contracts, we see provisions that talk about, oh, well, you're going to transport, or your services are the transportation. Well, no, I'm going to arrange the transportation. That's my role. So it's it's kind of arrange versus transport. Other phrases that you see in the contracts that are very problematic. Well, if you're saying, if the contract says, oh, well, you're the forwarder, but your carrier, or you will ensure that your carrier will. Again, if you're making those types of warranties that the carrier is going to comply with law, or they're going to use safe drivers, you're making warranties about the underlying carrier, and potentially creating tentacles that pull you into accident litigation. And so you want to revise that language to say things like, hey, I'll get the carrier to agree, which kind of brings us up to all right, so now what do we do on the back end? How do we protect ourselves with our suppliers? Again, if we're talking motor carriers, you can usually get a fairly favorable contract in place with your motor carrier. So you can get a contract that kind of anticipates what your customer is going to want to see in your contract. And it doesn't need to be a terribly onerous contract with your motor carrier. It can just be one where, as an example, they agree to abide by any and all applicable laws. They agree to indemnify you and your customer if they cause a highway accident. They agree to highway accident liability. They agree to some standards with respect to their equipment. You start to check off some of the boxes that your customers require, things like insurance of the underlying carrier, and all of a sudden now you can tell your customer, hey, I got the carrier to agree to those requirements. Now, once you move away from motor carriers, your ability to do that obviously is far more limited, because you're not going to get a steamship line or an air carrier or a rail carrier to give you any special terms that aren't otherwise available. And so that's where it really becomes important, to talk to your customer and make sure that they understand that at the end of the day, the transportation is going to be performed by an 800-pound gorilla, and here are the terms of that transportation, and we can agree to manage that and agree to make sure that we're using providers that accept the right kind of cargo liability, and essentially operate in accordance with industry norms. But we can't just be offering whole cloth warranties about what the carriers will be doing, or even in those instances what they will agree to do. So you really need to look what your customer is requiring, and then on the back end, what can I manage? How can I avoid the gaps, if you will, between what I've promised my customer and what I can get from the actual carrier. So I think that's, as we're running out short on time here, actually we're out of time, that brings me to our last substantive slide here, and that is liability of subcontractors. And if you could see me, I'm using the term subcontractors in air quotes. So, and what I mean by that is, when I'm representing a logistics company, especially, again, and this very much depends on your role. As an example, an international forwarder arranging ocean through an NVOCC, or an air freight forwarder arranging air under its airway bill, you do hold out as the carrier, and so you are saying, I am going to transport your stuff, and I'm the carrier, and I'm responsible for your stuff. And so then, it is typical to think of the underlying providers as your subcontractors. But if you're a property broker, as an example, or you're maybe operating as kind of an agent, if you will, those entities are not your subcontractors, right? Because what you've agreed to do is arrange transportation. So a subcontractor to you would be maybe another broker who's arranging the transportation. In other words, you want to be very clear in your description of your services. All right, am I arranging the transportation? And if so, then what I'm saying is I'm responsible for doing a good job arranging for the movement of your cargo. I'm not responsible for the actual movement. And that's an important distinction, and it's one that, again, doesn't apply to all forwarders. It depends on what hat you're wearing. So you need to think about things like, if I'm an NVOCC, do I want my bill of lading to say that my customer cannot sue my subcontractors? In other words, do I want to make sure that all claims roll through me? Do I want to say that, never mind, hey, this is my liability. If you want to go and sue the subcontractor, you go right ahead and do it? That sounds appealing. It can be problematic for you, depending on now you could be fighting fights on both sides. So it's important to think through those nuanced details in your bills of lading, your airway bills. On the flip side, in your customer contracts, what hat are you wearing? Do I want to be agreeing to indemnify against the acts and omissions of these underlying parties? Again, if we're talking a motor carrier, that is not a liability you want to take on, because they're not your subcontractor. You're not sitting there in the truck with the driver. You're not controlling the driver. We don't want to be responsible for the highway accident liability that they cause, because frankly, there may not be insurance coverage for that contractually assumed duty to be responsible for the acts and omissions of that third party. So you really need to understand, going back to Rick's introductory comment, you need to have a good understanding between risk, between your counsel, and between your customer as far as what liability you're actually taking on, and do you have coverage for that? And if you don't, that's a discussion to have with your customer, because if you don't have insurance for it and you don't have protection for it, then obviously you don't want to be signing up for that liability. And I think that's a very fair discussion to have with your customer, that, hey, the liability rests with the underlying carrier. It's not with me. So that's all I had on that slide, and I think that may have been our last substantive slide. So I know we're a little bit past time. I apologize for that. Rick, I don't know if we had any additional questions that came in.
We did not at this point, but I do, folks can think of anything after the fact, or if they do have any questions, if they listen to the recorded webinar, please get back to us, and we're certainly happy to kind of take it offline. But I do want to thank both of you guys for being able to present on this subject. It's certainly one that I guess we might say we get tired of, but it never goes away. It's a very big deal in the industry, and something that I think we all have to be very aware of. So if there is just any couple, we do have a few minutes here, just a couple minutes to get a last-minute question in, if anyone wants to type it in. But we are kind of running out of time. Just some comments that are coming in. Much appreciated. Good webinar. Great job. And I echo that as well. So Jake and Nathaniel, I want to thank you for bringing your experience and professionalism to our webinar series. And for everyone in the audience, please do note that we'll have the recorded webinar to you in the next couple days. And again, if there's any questions, feel free to get them back to us. And when you do get the survey, please complete that. Let us know what you want to hear from us and our partners, and we'll be sure to put that in motion. So again, thank you both for contributing.
Welcome.
Thank you. Appreciate the opportunity.
Okay. Well, that ends the webinar, and thank you all for attending. Take care, everyone.